on this morning's docket. Case number 113200 in the matter of Larry D. Ehrlich.
May it please the Court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, I'd like to reserve 2 minutes.
2 minutes is granted.
The hearing in this disciplinary case occurred on September 17th of 2014. Respondent appeared in person at that hearing with counsel John Ambrosio. This is a companion case, or the two cases were consolidated with the second case on the docket, the Supreme Court docket this morning. The case was submitted to the panel by stipulation. The respondent admitted to violations of 2 rules of professional conduct. Rule 1.4, communication, for his failure to promptly advise the complainant, actually his client, not the complainant in this case because this matter was self-reported, but I will be referring to her as the complainant, that her personal injury case had been dismissed. And KRPC 5.3 A and C, which deals with responsibilities regarding non-lawyer assistance. And this basically was the respondent's failure to supervise Mr. Klein, the respondent in the second case before you today. The respondent did not take exceptions to the findings of fact or conclusions of law made by the panel in this case. Just a little bit of background, and then a couple of things that have occurred since the panel hearing. I spoke to Mr. Ambrosio and to Mr. Kavanaugh yesterday, who both agreed I could update you on the status of some cases which are relevant to these 2 disciplinary cases. Those 3 pieces of litigation are, number 1, the workers' compensation case. This was a case filed by Mr. Klein in 2009. And in May of 2013, after Mr. Klein was reinstated to the practice of law after being suspended by this court for 3 years, an award was issued in that workers' compensation case. The respondent indicated to the complainant in the case, his client in the case, that he was going to file a demand for compensation in the case because the workers' compensation carrier had not, in their estimation, timely paid out that award. As it turns out, what he told his client was not true, was false, which led the client ultimately to terminate the representation of Mr. Klein and Mr. Ehrlich. That case then went to the Fleece and Gooing firm, and some attorneys in that firm have handled that case since that time. The award has now been collected and distributed to the complainant. The attorneys at Fleece and Gooing continue to work on the case post-award in an attempt to compromise some future medical, which would have happened under any circumstances, and continue to work on the work disability rating, which could result in some additional money to the complainant. There is then the personal injury case. This was related to the workers' compensation case. It was a third-party case brought against the individual who was driving the car that injured the complainant/client in this case. This case was filed by Mr. Ehrlich, the respondent in this particular case. And this case was dismissed due to the failure to properly serve the defendant in the matter, which led to the findings by the panel by stipulation that both this respondent and the respondent in the second case did not properly communicate this information to the client in that particular matter. In that case, the defendant in that case had $25,000 in insurance coverage. If that would have been recovered, the workers' compensation carrier would have had a lien against that amount of money or any amount of money that was recovered in the case. If recovered, there would have been the possibility that the workers' compensation carrier would have compromised that claim. We don't know if that would have happened or not. I guess you could call it speculation, but when you look at the ABA standards, they talk about actual or potential harm. If the matter had been compromised, the amount had been compromised, that's money that could have been recovered by the client in that particular case. Finally, we have the underinsured motorist case. That was filed by Mr. Ehrlich when the complainant/client was still a client of the firm. And this is this is information that's not part of the record because at the time of the disciplinary case, the underinsured motorist case was still pending. That case has now been resolved, settled to the satisfaction of the complainant/client in this case. And that's the new information that all of us agreed we felt that you should know. You should also know, this is part of the record, both respondents were covered by malpractice insurance at the time these acts occurred. It's my understanding that no claims have been made against them at the present time, but they are covered by malpractice insurance. My recommendation in the case was public censure. The panel in the case recommended the same. The respondent requested public censure at the hearing. Basically, I relied on two or three things, but the main thing I relied on in making this recommendation are the letters of support provided by members of the bar, the Wichita Bar, prominent attorneys in my estimation who without fail praised the respondent's character and reputation. Also noted that there was no dishonesty or selfish motive in this case, and I believe genuine remorse does exist. Thus my recommendation for public censure. I'd be happy to answer any questions.
Counsel, do you have any more details on how the underinsured motorist claim was resolved?
I don't. I know it was resolved to the satisfaction of the complainant because I talked to the attorney who represented her in that particular case. I asked for the amount. He wasn't comfortable in giving it to me, so that's the information that I have.
All right, thank you. Any more questions? Thank you, counsel.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. We have absolutely no agreement with what my colleague just stated to you. We have no disagreement with the panel report and the panel recommendations. The suggestion was made at the panel by the Disciplinary Administrator's Office for public censure. We made the same suggestion and the panel agreed. There is no doubt that the respondent was acting as a supervisor to Mr. Klein when Mr. Klein was his law clerk and when Mr. Klein acted as an associate attorney. And there is no doubt, and my client fessed up that he did not properly supervise that respondent, Mr. Klein, in either situation. For that, he's sorry, and he has no excuse. He also agrees that he did not inform the client that they were time barred and that didn't do that for such a long time that the client could have been harmed. He admitted that, he fessed up to that, the panel, and was remorseful. So there's no doubt there was a 1-4 and a 5-3 violation. What I worry about is that you will consider the old discipline that was meted out 24 years ago. In that case, in Ray Ehrlich, where I represented, that was the first case I did up here, where Mr. Ehrlich appeared, you suspended him and then allowed him to come back after 1 year to practice law. 24 years ago, Mr. Ehrlich was profoundly depressed. He had all kinds of problems. They placed him on medication 24 years ago, and he did therapy for about 2 or 3 years. Now, he doesn't have to go to therapy anymore. Now, he doesn't have to take any medication. He has beat the depression, which is a very unusual situation. And he has been a great member of the Wichita Bar, acting as claimants and plaintiff's counsel in many, many cases. As Mr. Haslett indicated, he has a great reputation with both the defense bar and the claimants and plaintiffs bar in Wichita. He does good work on behalf of his clients. He has no problem with discipline since that bad time 24 years ago. He has turned over all problems to the carrier. I think the claimant or the complaining party is made whole. This is a good lawyer who made terrible mistakes 24 years ago because of his depression, which he stood up to the plate. He took the 1-year suspension. He came back and he worked hard. Not only on that, he worked hard on his career, and at 69 years of age, he's a great member of the Wichita Bar. I urge you to follow the suggestions of the panel in this case. My client would now, with your permission, like to address you.
Certainly.
Thank you.
May it please the court. As Mr. Ambrosio has indicated, I was before this court more than 24 years ago for my misconduct in handling several cases during a very challenging, dark, and difficult period in my life. as I was suffering from depression that I didn't know, quite frankly, at the time, and also quite frankly, from burnout. After my 1-year suspension, I returned to the practice of law with the firm Render Camus in Wichita, where I have been ever since. I've overcome my depression over time, started taking better care of myself, and have worked extremely hard over the past 20 years in building up my reputation within the Wichita community and elsewhere to be a good and competent and hardworking attorney. Having said that, I recognize I'm here before the court for improperly handling a personal injury claim regarding a client for my failure to supervise Mr. James Klein as a legal assistant and later as an associate attorney on the case. I'm extremely sorry for and apologize to this court, to the legal profession, and to the client involved for my conduct. And I agree with the panel findings. As Mr. Ambrosio said, I will be 69 years of age here in a little over a month. I still enjoy practicing law and would like the opportunity to continue the privilege of practicing law in the state of Kansas. Thank you.
Counsel, could you refresh my recollection on the justification for not advising the client that her suit was time barred?
I have no excuse. I think the court, in reading the record, I should have. I trusted what Mr. Klein was telling me and that it would be resolved, but that doesn't excuse me in not telling her. Quite frankly, I don't know. I just, something that I thought would get resolved where, we could discuss how it happened, how it got resolved, quite frankly. But I don't have any reason. I should have called her in, let her know what happened, recommended a couple of attorneys, or at least, at the very least, discuss with her what had happened and if she felt comfortable about seeing if we could do something about still making that recovery, but I simply didn't. I don't have a reason, quite frankly, Your Honor.
Very well, thank you. Any more questions?
At the time that suit became time barred, you were still attorney of record, were you not?
That's
In other
correct.
words, Mr. Klein could not practice law.
That's correct.
And I'm a little curious, what kind of relationship, you say assistant, if Mr. Klein was not authorized to practice law, I'm curious as to why he was in charge of getting the service, a process. Why wouldn't that be the ultimate responsibility of the attorney of record?
It was my responsibility. I don't believe I said that it ever was his responsibility. I believe, if memory serves me right, Your Honor, I think by the time it was dismissed, that Mr. Klein, I believe, signed off on that journal entry, and I think that's after he had gotten his license back.
Any more questions? Thank you both.
Thank you.
Thank you.
And unless the court has any questions of me, I will waive rebuttal.
Any questions of counsel? Thank you. We thank all of you for your comments this morning. Court will take this matter under advisement. We now